platform has urged INEC to be impartial in the rerun election. Mrs. Teresa Paul called on other women groups to wake up from their slumber and support the historic possibility of having a first female governor in Nigeria.
Maybe they
first
elected
governor.
They had us yesterday. And I don't know how Kingsley will interpret, impartial.
No, well, I mean, INEC has striven very hard to be impartial in this election. And the election, of course, covers only those wards where there were problems when the elections first took place on the 11th of April. That's what happened, yes. But let me just throw in this story before we wrap this up.
Yes.
On page 45 of Leadership, there's a story there about Lagos, that the internally generated revenue of Lagos has moved up from 20 billion naira monthly as it was in 2013, and now is 23 billion naira monthly as of 2014. So Lagos IGR is now 23 billion naira every month. That's the highest IGR in the Federation.
There's this other story, finally. A traditional ruler in Funaka, a local government area of Gombe State, says he was attacked by politicians just because he stopped them after accreditation from distributing 1,000 naira and 500 naira to voters who were waiting on the queue. The traditional ruler was assaulted and his robe torn. However, he was magnanimous enough to prevail on his subjects not to attack the politicians. The politicians also claimed that he was alleging and calling on the voters to vote a particular party. He has denied that and said he, as a father of all, cannot tell them to vote for a particular party. Rather, he was trying to stop what they were doing, which was a violation of the Electoral Act.
Okay, Bayo, just for working class mothers who having to deal with the issue of getting a good nanny or a good housekeeper, there is a piece for you on the inside page of Leadership on page 44, and it tells you how to hire a good nanny. I thought I should just point that out.
That's right.
I think you should also add that there is a law now that says that you cannot hire a nanny who is less than 12 years old. If you
that's
do,
correct.
you're going to prison.
That was an act.
Definitely.
Bayo, this issue of kidnap, there was an incident, if you recall, in 1991 in Lagos, where a driver who was taking the children of his boss to school, just ran away with them. It was a big story then in 1991 in Lagos. Again, it was a happy ending to that particular incident. Bayo Atoyebe would like to thank you for being with us this morning, and we hope to see you tomorrow.
Thank you very much for having me.
Okay. It's Good Morning Nigeria, live on the network service of the NTA. We're taking a short break now. When we return, we proceed with our principal item for conversation this morning, namely the Supreme Court decision on the Ekiti elections.
The body to sweat, which attracts germs that are easily passed from one person to another.
What keeps you so cool, man?
Dettol Cool combines Dettol's protection with added menthol to protect from germs. Cool gives you maximum protection against germs every day from head to toes and an invincible icy feel. For super cool confidence, use Dettol Cool.
Dettol. Be 100% sure.
Your mommy could cook like mine, don't you? Don't you wish your mommy could laugh like mine?
3 Crowns now comes in powder. 3 Crowns milk. Healthy moms, happy families.
Do you know that you are exposed to up to 100 illness-causing germs every day?
I encourage my kids to learn new things, and if they get hurt, I rely on my Dettol to fight germs. It's like my own first aid kit.
My family needs protection from germs. My Dettol disinfects surfaces and clothes, keeping them clean and safe from germs.
Okay, the Supreme Court on Tuesday dismissed the appeal by the All Progressives Congress, which was still challenging the election of Ayodele Fayose as governor of Ekiti State. Now, the election took place on the 21st of June last year. The APC had petitioned first, and the Election Petition Tribunal also dismissed the petition. The APC then proceeded to the Court of Appeal, which also dismissed the appeal, and then went on to the Supreme Court. And on Tuesday, the Supreme Court ruled finally on the matter. There are many grounds for dismissing the appeal, because there were a number of prayers that were contained, or grounds of appeal that were contained in the matter, including, of course, whether or not Ayo Fayose was qualified in the first instance to stand for the election on the 21st of June last year. Now, what were the grounds? The first was that Ayo Fayose had been impeached in October 2006, and therefore he didn't qualify to seek re-election. Also, there was a question of whether or not he had submitted genuine or forged certificates. That's a higher national diploma. Now, the key issue, of course, that we'll be focusing on today, but the Supreme Court also dismissed that and said that the Court of Appeal had earlier determined that matter, and it was therefore res judicata, and there was no point bringing it up again at the Supreme Court. So the key issue we are focusing on today will be the dismissal of the appeal on one of those key issues, namely the implication of the impeachment and removal of a governor from office. Now, if a governor is impeached, what does it imply? What does it mean? The Supreme Court, of course, held that other than impeaching the governor, the further steps ought to have been taken. And namely, if it was on grounds of embezzlement, the person who was impeached and removed from office ought to have been prosecuted, either in a competent court of law or the Code of Conduct Tribunal. This is the background. There are other matters that will be taken up in the course of this conversation. We have three guests who will be having this chat with us this morning. Claire, we have two of them here in Abuja, and then two at Sound One at the Enugu Network Center. I'd like to introduce the guests right away, Claire.
Yeah, all right.
Yes.
Of course, we have already joined us in the studio here in Abuja, James Ocholi, a senior advocate of Nigeria, SAN. We'd like to thank you for coming. Also here with us is another very senior advocate of Nigeria, Joe Age. Gentlemen, we thank you for coming.
Thank you. You're welcome.
And from our Enugu Network Center, Professor Reyes Achara, senior advocate of Nigeria. Prof, thank you for joining us.
Thank you. I'm actually not a senior advocate of Nigeria. I'm just a professor of law. You then. Don't
worry, you get there. You get there. All right, let me quickly start with you, or probably with the senior advocate here, who is a learned friend. For those of us who may not come within the bracket of learned, friends, as lawyers, refer to themselves. The case, the Supreme Court, we know, let's bear that in mind, is a final, has a final say on any legal matter brought before it. That is certain. But the decision on the issue, at hand, the issue of impeachment of the petition brought against, Governor Ayo Fayose by the APC raises a lot of questions. Question of interpretation of impeachment. Maybe quickly interpret that for us.
Yes. Well, it's just that we don't follow what the Supreme Court have been doing. That issue, not a purely impeachment, it came up during Atiku's period when Obasanjo was president. Atiku was indicted, and they said because he was indicted, he was not qualified to run. He went to court, and the court said, no, indictment alone is not enough. You must be charged to court and convicted. So it's not too different from impeachment. Impeachment is a panel put together by this chief judge on the request of the House of Assembly to investigate and indict a governor. And if he's indicted, he will be removed from office. You now have, if it's a criminal, to charge him to court. Because a panel is not a court. In Ayo Fayose's matter, he was indicted for violating the Code of Conduct law. There's a Code of Conduct tribunal. Then he would have been charged to that tribunal. If that tribunal had found him guilty and convicted him, he would not be qualified to contest. But they just stopped at saying, look, he violated the Code of Conduct Act, and so he should be removed from office.
it does not imply, that if you are impeached, you've committed a crime.
No, it's not it's not a court.
Oh.
You must be convicted by a court of law or a tribunal. That's the important thing.
So a court of competent
jurisdiction. No, well, a court of law. Because we can't call an impeachment panel a court. It's not a court known to our law.
Okay, well, let's bring in now Senior Advocate James Ocholi. We haven't seen you for a long while. What's your take on this very interesting decision that we have had from the Supreme Court?
I differ a little. My take is impeachment proceedings are concluded the moment the panel enters a verdict that the allegations against the sitting governor are approved. The results of that are forwarded to the House of Assembly, who effect the impeachment. The House does not necessarily have to go a step further to secure a conviction. I can bet you any House that sets out to do so will most likely be viewed as witch hunting. In my view, if the purpose of the impeachment proceedings are to remove the governor from office, the moment that governor is removed from office, impeachment stops. I think it should now be the functions of the Attorney General of the state, who, as a public officer, who, as the chief law officer of the state, and wanting to sanitize the state, whether it be a governor, whether it be any other person, whether private or public, where a crime is seen to have been committed, it behoves on the state to instill discipline and sanitize that state by taking that step. The unfortunate thing we have is that majority of our attorney generals, whether at the state level or at the national level, are either sycophants or they are tied to the aprons of the appointer. So the moment their principal is removed, they do not have the strength of character to instill the discipline of the law by taking the step further. Now, but let's bear in mind, sir, that it is possible to secure an impeachment and remove the sitting governor, and you attempt to prosecute in court and fail. It's possible because the standard of proof of criminality and finding or securing a guilt judgment from the court will go through several technicalities of whether your charges are properly framed, whether there's duplicity, whether there's all manner of things, and you may have a way, one way or the other, that the case gets struck out, either on technical ground or for some reasons, or for failure of proof. But that standard of proof is not the same as the standard of proof required in a panel, which is seeking to find whether the governor has been properly indicted for these offenses or not.
Okay, well, the learned senior advocate James Ocholi, I think that there are two legs that we are dealing with here. First is impeachment and therefore removal from office. We will deal with that aspect, and also the consequences of that impeachment and removal from office, which is the leg that you just touched on now. But Claire earlier introduced from our Enugu Network Center, Professor Reyes Achara is actually a professor of constitutional law. Professor Achara, if we can see you there at the Enugu Network Center, I would like you to come in now with your comments in general before we begin to go into the specifics of this discussed this morning.
Mr. Sadola, I particularly like the distinction you drew just now, because this is a common misconception. Impeachment is not necessarily a removal. You can be impeached without being removed from office. So impeachment precedes removal. Impeachment is really an indictment, an accusation, and it's not restricted to public officers alone. It's also not restricted to chief executives, whether at the federal or state levels. In fact, in the case of Ojibara, versus Kwara State Independent Electoral Commission, which was decided by the Supreme Court in 2006. The impeachment was against commissioners of the Kwara State Independent Electoral Commission. So the fact is, when you make the impeachment, when you cast that slur on a public officer, you're now saying, this person, I believe you have done something wrong. And then it now gets into trial. In many jurisdictions, the jurisdictions we borrowed from, that is in England, the impeachment is done by the lower house, that is the House of Commons. And then the trial is done by the Senate. If there's a conviction at the upper house, then you will be removed. It is therefore possible to be impeached, as in America, where President Clinton, mind you, was impeached, but he was not removed because they did not get the requisite majority at the Senate to remove him. So we need to be clear about that distinction, because it's a common misconception that has taken the rounds, since our 1979 Constitution. There is in common journalistic parlance that when you just say impeachment, people assume that the officer has been removed. So I just want to make that clear.
Okay, let's get back to the senior advocate of Nigeria, James Ocholi. You earlier, of course, your opinion differed from the judgment, but the Supreme Court had held that, of course, in section 1821E, that the Constitution laced, the grounds for disqualification and declared that impeachment or removal, well, impeachment is not among the grounds. So I would like to know, what is the wisdom in not adding impeachment as a sufficient ground for removal of barring a governor from recontesting?
Okay. First of all, let me say that I do not differ in opinion from what Supreme Court said. I agree with them that as the law stands today, as the Constitution is today, Section 182, subsection 1E is very clear. Impeachment is not contemplated in that subsection. Therefore, the Supreme Court is quite right, but I think I commend the ingenuity of the lawyers involved on both sides, because they were trying to push the law, develop the law a little bit further. But as the law stands today, it is only when a conviction and a guilty sentence or a sentence is obtained against anybody that it can be used within the framework of 10 years to disqualify the person from seeking a public office. But my thought, which I just heard, is that does it necessarily mean, therefore, that once somebody is removed or impeached from office, and let me say that distinction given by the professor in Enugu is looking more like on the American Constitution. As far as our Constitution, Nigeria, is concerned, there is no drastic difference, as he has sought to make, between impeachment and removal from office. Nigerian Constitution is very clear. The House of Assembly can't carry out that impeachment after the panel set up by the Chief Judge of the state has entered a verdict of guilt. But that guilt is not the guilt that a court is not equivalent to the guilt verdict that a court can produce. But wherever that impeachment stops, which in Nigerian context means removal, wherever that proceeding stops, I have said that most of the times, in fact, I don't see where they have gone beyond it to go into criminal prosecution. It stops there. I think from this judgment, the lesson we now learn is that if public officers are to be held accountable, accountability of the office is not only by removal from office. We should go a step further to sanitize the system by insisting on criminal prosecution. If the DPP is given the file, he goes through it, and he finds that a criminal offense has been committed, then he can frame necessary charges in court.
Well, that's the point. I mean, last year when we had a rash of impeachment and subsequent removal from office, the issue came up, and it was being argued whether it was solely a political weapon. But Barrister Ochola, the point you just made now is elaborating on that, namely, yes, there could also be criminal consequences, which always were not followed up. But there's an aspect, gentlemen, let me come back to Professor Achara. There's an aspect of the decision by the Supreme Court, again, relating to impeachment and removal from office. The Supreme Court held on Tuesday that there were, in fact, two efforts, to get Fayose out of office in 2006. That the first one ought to have served as res judicata. In other words, first one ought to have settled the matter, because the first panel set up by the then Chief Judge of Ekiti State didn't find him guilty. But another one, of course, knowing the political tempers at that time in 2006, a subsequent panel was set up by the then acting Chief Judge. Now, what does this say with regard to the propriety of impeachment proceedings? Because the Supreme Court was quite clear that the impeachment in 2006 subsequently was an illegality.
Yes, I think that it's just a peculiar thing that has arisen from the special facts of this case. It wasn't as if there was an intention to have one proceedings and then thereafter to ignore the first proceedings and go on with another one. The people who did what they did in 2006 did it on the premise that the first proceedings were instituted by a wrong appointing authority. In other words, they were doubting the vires of the substantive chief judge at that time to constitute the panel that cleared Fayose. So the new acting chief judge then set up a different panel, as it were, giving the impression that this was the proper panel that should hear the matter, and they came to the result they came to. The good thing, however, is that ex post facto what had happened, the Supreme Court has now made a declaration that the very first panel was properly appointed, and that the subsequent panel, in fact, the person who appointed them was eventually thrown out by dismissal by the National Judicial Council. So that is, I think, what really has happened there. But ordinarily, it stands to reason that if a panel has gone through the motions of, investigating and making a report saying they found nothing to the charges, nothing to the impeachment, then the matter stops there based on subsection 9. But if they then say that there is something to the charges raised by the 1/3 of the Legislative House, then it is the trigger for them to then go on to have a vote that will determine whether the person will be removed or not. So it's just based on the peculiar facts of the situation. I don't think the Kwara State panelists were, did not realize the fact that they did not have the right to try this man twice. That would be, totally wrong, and the Supreme Court just brought that to their attention.
Well, yeah, let's come to Joe Aggie with us here at Abuja Studios. Just listen to Professor Achara. What's your reaction?
Yeah, my take in that is that first, we must realize that impeachment does not necessarily connote criminal offense. It can be used as a political tool. Maybe in the morning they greeted you, the speaker greeted you, you didn't answer. He can say it's an impeachable offense and you are removed. Let us take our mind back to the Taraba case. The acting governor or deputy governor was impeached. What did the Supreme Court say? In fact, that impeachment took less than a day. And the Supreme Court said, look, impeachment is not a joke. But in just one day, they were through with him and he was thrown out. He went to court and the Supreme Court said, you were wrong. It also happened to Ingilari. It also, in fact, in Nasarawa State, you remember the panel said, oh, look, this man, there were speculations that it was, that Labara Maku was sponsoring them. The people came again to Abuja, oh, look, we must remove Al Makura. So impeachment, we must know that impeachment per se does not connote a criminal offense. And that's why the Supreme Court in Abuja said, look, being impeached alone is not enough to disqualify you from contesting an election. Because, one, if maybe you belong to a minority party and they frame up anything, not even crime, and say, look, oh, we find you guilty, you are impeached, it will be unfair to deny that person the right to contest again. Unless you are impeached on grounds of criminality. That is when, like my elder brother said, Ocholi, then the Attorney General or the DPP or the IG of police, in fact, if the Attorney General cannot prosecute, the IG, if there's a crime, the IG can arrest the person and charge him to court. They have a right of prosecution. So it doesn't have to be Attorney General. All I'm saying is that our office holders, like the IG, the DPP, should have the courage. Where a crime is committed, deal with the person. And we can't just say, like we say, oh, look, you are impeached, so you must have committed a crime. No. And like Ocholi said, Professor, that you might be impeached and not removed. Impeachment per se, if you look at the meaning, is like an indictment. Then the House, it's okay, you stand impeached and you are removed from office. Once you are removed, like I said, if there is crime, your embezzlement, you didn't declare your assets and you violated the code of conduct, then they take you to the code of conduct tribunal. If you stole money, they charge you. Of course, we are aware of ex-governors who are standing trial with EFCC. So you can have immunity as a governor. After your tenure, you can be prosecuted.
After removal from
After removal from, you can be prosecuted. So the Supreme Court clearly in their wisdom said no, impeachment alone is not enough to disqualify Mr. Fayose. And also they added that, look, go further. If there is crime, prosecute him. Just like we said, you hear the Supreme Court clearly said the second panel was wrong. Why would you, a chief judge, have set up a panel and say we don't find the person guilty or liable? Another one comes, acting chief judge. Oh, look, and then I think how many days? He was found guilty and he was thrown out of office with all those circumstances. So we should know that impeachment should not stop anybody from running elections.
You know, I was going to ask, why offenses that could lead to the impeachment of a governor, not enough grounds to disqualify him from recontesting. But you have said that it could be a political tool. I don't know if SAN Ochile agrees with you, but SAN Ochile, many people believe that the fact that a governor, was investigated, found guilty, and of course was impeached and went ahead to remove him from office, should have been enough grounds to stop him from recontesting.
This is purely my sentiment and I'm going to express. Let me tell, if impeachment is not politicized, if it is not abused and maneuvered by politics, and it is properly done, I think grounds upon which a governor is impeached, they must arrive at the verdict that there is either a gross misconduct, something grievous should warrant only the removal of governor. That such removal should be seen as a relief that a man who has soiled his hands with all manner of fishy, dirty deals should not be allowed to hold that kind of office as governor of the state. So speaking on that ground, I think there is a need to take a review at our law to see whether Section 182, Subsection 1, should not be amended to include such ground as when a man is impeached. But again, because of the issues we have raised about the sham that sometimes are done in the name of impeachment, we need to be very careful so that we don't make our public officers vulnerable to some very powerful individual use the tool of his powers and get somebody removed, and the next day he's no longer qualified to hold office for 10 years. You know, the beauty of the Constitution is that a trial in criminal court cannot easily be stage managed. You go through the final processes, the DPP does his work, the FCC does their work, your lawyers do their work, the rules of fair hearing comes to play, and after a conviction, if you are convicted at all, you have the chance to go on appeal, step 1, step 2, step 3, to validate that, and if it's not proper, you set aside. But impeachment, where do you appeal to? So if impeachment is used as a ground to disqualify, a few people who don't like your face gang up against you, they remove you from office, and then the next day you say you are not qualified to come into office again for 10 years. The effect will be so devastating. So I think one has to weigh the several implications in it.
Where do you appeal to? That will take us to the next leg, as Kingsley will say, of our discussion. That's, of course, implications of the Supreme Court's judgment. But you have heard a personal opinion about the question I asked you. I don't know if S.A. Enoche has a personal opinion on that matter as well.
I won't talk about a personal opinion. I will take advantage of this time to say a governor is removed from office for gross misconduct. And our constitution defines gross misconduct to mean a grave violation or breach of the provisions of this constitution, or a misconduct of such a nature as amounts, in the opinion of the House of Assembly, to gross misconduct. It becomes subjective. That's why I say it can be used as a political tool. In their opinion, the law does not specify what misconduct is. Like I said, if the speaker greets the governor in the morning and he doesn't answer, he says it's misconduct for you not to accept my greeting. That is his opinion.
Well, I was just wondering, Professor Achara, I would like you to come in here. We're discussing now very briefly issues that may warrant a reform of some of what we regard as problematic provisions in the Constitution. Now, that aspect dealing with gross misconduct being a grave violation should the other leg of the interpretation also go away, that namely what is in the opinion of the House of Assembly. I mean, as Barrister Agui has said, I mean, and we all know this, that the opinion of the House of Assembly has been defined often in troubling ways, as we have found in cases of impeachment and removal from office.
With the greatest respect, you're exactly right about the sentiment expressed, you know, the troubling ways, as you so elegantly put it, you know, in which the various legislatures have exercised, you know, their decision-making process on this area. But I think that sometimes we overlook the philosophy behind particular, to the contrary. That subjective part of the provision is what really builds that provision. Let us understand the philosophy behind impeachments and removal of public officers, especially in a country where the Constitution gives immunity, quite apart from the enormous powers some of the executives exercise. So this is the only way you can answer some of their excesses. And you're giving a political power to a political institution in order to curb a political, as you might call it, a behemoth. The kind of powers given to a chief executive are just immense. So you need this body of politicians in the legislature, elected by the people, to deal with this special power, the issue of removal. You cannot, for example, charge a governor or a president, you know, for a crime in court during the period of his office. That is why you've given this power to the legislature to do it. And it is important for us to realize this. In England, for example, it will be by a simple majority of the House of Commons that the impeachment will majority at the Senate for the trial, House of Lords for the trial to go through. Removed, even though that has only just been done once for a king, you know, that's Charles II. You know, so the important thing is, if a sitting president has been so unmindful of the political dimensions of his job and has become so out of touch with the elected people representing the electorate in the legislature, that 2/3 of these members find the need to remove him. and are so persistent in this need to remove him that they have gone a different body, the head of the judiciary, to make a complaint saying, bring us again independent persons, 7 persons of unquestionable character, to investigate this our allegation, this our impeachment. When these 7 persons come to a determination that yes, that is correct, that this is not just a misconduct, it is a gross misconduct, and it is brought back to the legislature, and the legislature again, by 2/3 majority, in a country, especially a third world country where we know the powers of a sitting chief executive, and 2/3 of the members of that house still say, yes, this person is so, terrible that we have to push him out. After it's all done, it is not for to start interfering. This is something that has been coming up. It read its head a bit in Abaribe's case at the Court of Appeal, and then for the first time when this sort of matter had come to the Supreme Court in the Oyo case, Governor Ladoja case, it was unfortunate that in curbing a mistake in procedure, that the Supreme Court went beyond the very good job they had done to start interfering with the question of who determines what constitutes a misconduct. It's not done anywhere in the world unless we choose to discard our constitution, discard ages, centuries of legislative and legal practice in other countries where we've borrowed from, in England, in America. Then we really have to put a stop to this. The judiciary, of which that's my personal, my constituency. But let us face it, the judiciary is constituted of very intelligent people, but they are unelected. They don't have anybody's mandate. It is not right that 5 or 7 justices of the Supreme Court, no matter how brilliant, should be able to override the subjective decisions of 2/3 majority of members of the Legislative House. What we can say is, let them just interrupt when these people don't show they have 2/3, when they show they have not followed the steps. But once they have followed the steps in the Constitution, and they have come to the point of saying, this is what we believe to be a misconduct, for God's sake, if we have to have separation of powers, which is the foundation of our Constitution, we have to give a little respect to these different institutions of the tripod of government that we have under our Constitution. Otherwise, we'll be going somewhere else.
We're coming to you. Well, Professor Achara, you saw the senior advocate Ocholi, pop up on the screen, while you were explaining. I was going to ask him, of course, I'm going to ask your other 2 learned brothers, to respond to the aspects that you've raised there. But let's begin with Ocholi.
I have tried to appreciate position only to the extent that the fine principles are there. The House of Assembly identifies some wrong. They frame up some impeachable offenses, and they go through the judiciary, so they get a 2/3 majority, 1/3. They go to CJ and all that. But these procedures are subject to manipulations. And this is the game that the politicians are best in. Manipulating and subverting those principles and pushing through where the CJs and some acting CJs are put under pressure, duress, threat. If you don't constitute this panel, or the panel you are going to constitute, put these people inside this panel. We have heard of these things being done. The only body that can hold sway and insist on constitutionality, full compliance, is the court. The moment we try to push aside the court and say, look, court, don't interfere, because these are politicians, they are the only ones who can remove a chief executive. The moment we do that, we will open public officers to abuse without remedy. I think that the powers of court to interfere and to right whatever is wrong is the only means by which sanity can be instilled into governance, into impeachment proceedings, just like any other chat with my brother Silk shortly before we came in. If the judiciary stops functioning for 1 month in this nation, we will be in trouble. It is the only institution that can hold the balance between the aggrieved, the oppressed, the injured, and those who injure, because it will become survival of the fittest.
I was just wondering, sorry, before we come to the senior advocate, Age, I was just wondering, I would like you to take this along. You know, there is an ouster clause in the Constitution, that's section 188 sub 10, that says that the proceedings of the impeachment or removal panel or whatever steps taken cannot be inquired into by a court of law. So are we seeing now, by way of judicial interpretation, the fact that that subsection is being watered down and becoming almost an appendage, that is a vestige that probably will just fall out at some point in time? Who takes?
Yeah. You are right. That subsection 10 says, no proceedings or determination of the panel or the House of Assembly or any matter relating to such proceedings or determination shall be entertained or questioned in any court of law. My own position is that the law, the Constitution itself, have removed the powers of the court to interfere. But there's a rider. The court will not interfere if you follow the procedure. Courts interfere where an aggrieved person goes to them to say, look, yes, you have no jurisdiction to entertain this matter, but the law says you must first appoint a 7-man panel. You must have 2/3 majority. And if they have, assuming they have 1/3 majority, and they remove
as we saw in Dariye's case.
Yes. So the courts can't keep quiet. The courts come in not because it is impeachment. The courts come in because you have violated the same Constitution which empowers you to do what you are supposed to do. That's when the court comes in. The court they doesn't just come in because you were impeached and the reasons, the grounds were not solid. No.
No, I'm sorry. I understand. Claire, I'm sorry. Claire. Let's just pursue this point. Again, from the history of impeachment and removal of governors from office and of the close one that Atiku Abubakar had as vice president, the mentality that propelled in most of those cases seemed to be that, look, whatever we are doing cannot be inquired into by any court of law. Therefore, let's proceed. We set our own rules, we set our own procedures, we'll go ahead with it and inquire into it. That seems to be the mentality.
No, it's a wrong mentality.
Yes.
What the law says is that you ought to do your own part properly. Once you falter, the courts have the unlimited powers and jurisdiction to interfere and say you didn't do the proper thing, and this man cannot suffer this injustice when you didn't follow the procedure. You see, like my brother Ocholi said, sometimes they manipulate and they're in a great hurry.
That's right, that's the point.
In a great hurry, this man must go. And they forget that, look, the law says you must give a particular number of days. You might be short of 1 day. It means a lot to us in the legal profession. And then the court says, well, you are supposed to give 21 days notice. You gave 19 days. You gave 20 days. It is short of the constitutional provision. And so you have infracted on the law. And the courts cannot fold his hand to say, because they say don't interfere. And then you allow people to behave anyhow. That is when the court comes in. The court just doesn't just, like I said, they don't just come in because they don't like what the House did. No. The aggrieved person will go to court to say, look at the procedure. They didn't follow it. They violated it. And if the court finds out that they did, then the court will interfere and set aside the impeachment.
All right, we will take the second leg of this conversation, of course, talking about the implications now of failure to follow the legal process. And after we come back from this short break.
Yes, Hotel New Horizon has rebranded with upgrade of their facilities. Guests and visitors to Hotel New Horizon are certainly in for an amazing good time. Located in a very serene environment with a crop of well-trained personnel, Hotel New Horizon has tastefully and exquisitely furnished rooms and suites. Host your events at our fully air-conditioned, multi-purpose, pillar-free banquet hall. Enjoy our exclusive continental and national delicacies. Have relaxing moments at our state-of-the-art Fijat poolside bar and grill, opened 24 hours daily. Let us take the stress off you. Take advantage of our excellent outdoor catering services for all your events. Hotel The Horizon, situated at Plot 5, Candy Close, Wusetu, Abuja.
You are watching NTA, Nigerian Television Authority. For more information and news updates, visit our website at www.nta.ng, or you can follow us on Twitter at NTA News Now, or you can like us on Facebook at NTA Network News. Stay connected on our YouTube channels at www.youtube.com/NTA News Online. Watch our live stream at www.nta.ng/live. NTA, you can't beat the rich.
Still, Good Morning Nigeria live on the network service of the Nigerian Television Authority, Africa's largest television network. And we are discussing the implications of the Supreme Court judgment on Tuesday, throwing out the appeal by the APC and insisting that Ayo Faoshe was qualified to have sought re-election in 2014. Claire, before we went on a short break,
yes,
you were going to open up another leg.
I said
yes.
we will take the anchor leg of this conversation. And we do know, of course, I want everyone to bear this in mind, that the Supreme Court is the final arbiter, it has the final say, and the Supreme Court has ruled on the matter concerning the APC and, of course, Ayo Faoshe. But it had declared illegal the panel, of course, that impeached Governor Faoshe, June? That was June, October 2006. So we're looking at the implication, and I like us, Leonard Silk here, to enlighten us on the implication that this will have, of course, for the interest of the public.
Yes, what the Supreme Court has done is correct. They were merely interpreting the law. Section 188 sub 8 of the Constitution says, where the panel reports to the House of Assembly that the allegation has not been proved, no further proceedings shall be taken in respect of the matter. It's a law. There was a panel set up by the Chief Judge, and that panel found Ayo Faoshe not guilty. And then there was a contraption. Somebody became an acting Chief Judge and set up another panel. That person was infracting on Section 188 sub 8 of the Constitution, which says, don't do it again. Don't go back on it. And apart from that, the Supreme Court said the man who was appointed acting Chief Judge, his appointment was unconstitutional. So his appointment was illegal, his action was illegal. So they needed to clear the point so that people will know that once a man has been cleared, you don't just, because you don't like the decision, you now call another person, come, look at it again. So for me, they were correct, they were perfect, they were following what the law says. Because if they say, don't go further, it ends it. In fact, it's the same thing they tried to do in Al Makura's case. When the panel said they found Al Makura not guilty, they relocated to Abuja and were pursuing the Chief Judge to set up another panel. Oh, that one of them is a pastor in the church, one of all sorts of things. But the law says once you find out that the man has not committed any offense, the matter terminates there. So what the Supreme Court is doing is to bring sanity to our polity. That you don't just go after a man because you don't like his face. The panel was set up, you like them, they came up with a decision. That ends the matter, unless there's another offense.
That clarification is very useful.
Unless there's another offense.
That's, in other words, the rule of res judicata would apply to the first set of allegations against the target of impeachment, if it's a moving target or a sitting target. Professor Ray Sachara,
yes. Professor Ray Sachara, I don't know, how do you interpret that declaration of the court that the panel which sat on the impeachment of Governor Ayo Faoshe was illegal? What's your understanding? How do you interpret that?
I would think that at the back of your question, and you could correct me if I'm wrong, is that you want to find out what are the consequences in terms of the person who lost a benefit based on that impeachment. What are the consequences to him? Does he have a right to go back and get his term, the truncated term, the balance of his truncated term? Is there any room for him to get damages for the loss he has suffered? Should he add to the term he's currently holding? Does it prevent him from standing, facing further impeachments that have happened after that earlier one? That is current things. You know, that is my understanding, but in case I'm wrong, you could correct me. But if that's how you want me to proceed, then I'll proceed.
Please go ahead.
It's your understanding.
It's your understanding of
the question.
exactly.
Take it however you want.
Exactly.
Take it however you
One is that what went up before the Supreme Court was not a complaint by Governor Ayo Fayose on his impeachment. So there's such a thing called, you know, there's no judgment given to him as it were. He was not asked to go and get back the term that was truncated in 2006. And it couldn't have happened in any case because there's such a thing called obiter dicta. There are things that are very important, fine statements, but they have no relevance to the life issue in dispute. So it does not mean that Governor Ayo Fayose would now claim the balance of the tenure he had in 2006, which was wrongfully truncated. Now, getting to the next question, that is whether he will also be entitled to a prevention of things, because we all are aware that there is a current move to impeach him now. Now, it's important to know that the Supreme Court decided on events that preceded the current articles of impeachment that are currently in place. So there's nothing from the decision of the Supreme Court of 2 days ago that has any bearing with the current complaints by the legislature of Ekiti against Governor Ayo Fayose. So if they do the things appropriately, if they follow the rules appropriately, the courts will also do what they have done admirably today or 2 days ago. They will be dispassionate. They will take the facts as they come and they'll apply the law as the Constitution has provided. So it does not affect anything that needs to be done after the previous thing. What they decided on was the previous thing. So that is where I would like to clarify.
Maybe you'd also, sorry, Kingsley, please clarify for us as well, because I understand the panel was constituted twice. Is that constitutional? Is that right?
Which panel now?
That's
the impeachment panel.
Yes, the impeachment panel.
That's why the second, sorry, Prof, that's why the second impeachment panel was declared an illegality by the Supreme Court in its judgment of Tuesday. But Professor Achara, we'd like to pause you and then return to the two senior advocates we have with us here. Senior Advocate Ochola, you heard Professor Achara, deal with the consequences. Now, Professor, one aspect I would like you to respond to, in addition to other areas that you may wish to consider. Professor Achara appears to hold the view that the declaration of the second impeachment panel was by way of obiter. It would appear to be perhaps one of the core ratios of the determination of the appeal. In other words, one of the core reasons rather than a side remark. And follow up with the consequences of the declaration by the Supreme Court that, Fayose can't possibly benefit by saying, look, I lost so much, let me have the unexpired, unexhausted aspect of my tenure that was truncated by the House of Assembly. Senior Advocate James Ochoy.
I totally agree with Prof. Fayose had no relief that he was seeking before the Supreme Court. In fact, he had no relief he was seeking before the tribunal. Therefore, whatever was said only constitutes the reasons why the appeal of APC had to be dismissed. And that order of dismissal is the only enforceable order available in that judgment. It does not provide any other relief that was not sought in favor of Fayose. Therefore, I totally agree with the Prof.
Okay, Agi?
Yes. Well, on his unexhausted term.
Yeah, assuming, yeah, because the point now, yes,
that has been dealt with by the Supreme Court in Ladoja. You mentioned Ladoja's matter here.
Yes.
We can't go back to it. I mean, there is no issue there. All the Supreme Court tried to do is to streamline these things. Don't witch hunt somebody. Having found out that the man is not liable or guilty, that should end the matter. The next one was witch hunting. They only went in there to say, look, for us to learn that the moment the 7-man panel has said the governor is not guilty, that ends the matter. You don't just, because you don't like their decision, get a chief judge suspended, appoint an acting chief judge, set up another panel, they come out with a verdict of guilty. That's what they were just trying to say, because it reared its head again in Nasarawa a few months ago, where they didn't find Al Makura guilty. They said, no, these people were some of my friends, some of my church members. Look, get to set up another panel again. So what the Supreme Court have done here is to now enlighten us so that in future, once they have come up with a decision that the governor is not guilty, that ends the matter. You move on. That's all they have tried to do.
Okay, the Apex Court also held that failure to charge Governor Ayo Fayose, before the Code of Conduct Tribunal after he was impeached, as laxity on the nation's institutions. Who, at that level, I mean, who should have taken that matter up?
The Attorney General. The Attorney General of the state, or the DPP, or any interested person who can get a fiat. You can prosecute from where you can get a fiat to prosecute him.
I was just wondering, gentlemen, see, on the one hand, again, this is what arises when you are considering a judgment. Let me try to reduce it, to terms that our viewers, the majority of our viewers can understand. On the one hand, the Supreme Court said the first panel that tried Ayo Fayose,
that had allegations against him.
Had the allegations against him. The first panel was properly constituted, and it returned a verdict of not guilty. End of matter. So if he wasn't guilty, there would be no issues arising for prosecution. Now, the Supreme Court comes to the second leg of it and says, look, the second panel set up by the acting chief judge, who was subsequently dismissed by the National Judicial Council, was an illegality. But that second panel that was illegal, as pronounced by the Supreme Court, now returned a verdict of guilty, considering grounds of violations, that would have warranted prosecution. What then were you going to prosecute from a body that you had also pronounced illegal?
No, is it? Okay.
No, Charlie.
That is one of the issues I wanted to raise about this need or no need to prosecute. Supposing the 7-man panel returns a verdict of guilty, the House goes ahead to remove the governor. Prosecution is initiated. The governor, in the course of trial, gets convicted. But in the meantime, his suit at the upper level, going to the High Court, Court of Appeal, and Supreme Court to challenge his impeachment, sails through after he has been convicted. If the Supreme Court or the Apex Court now nullifies his removal, what happens? Where one has been wrongfully removed or impeached and later on convicted. I think that there are lots of variables involved in the processes. And I think there is a need for a review of that section 182.
Okay, yes, indeed. I was going to ask Professor Achara, with regards to the amendment, to the Constitution, are there lessons that we could, learn from all this?
I find it very difficult, to slightly disagree with the suggestion by the learned senior advocate, Mr. Ocholi, about reinstating what, in fact, the first Constitutional Alteration Act removed, as it were. You're bringing in a provision that will authorize something that is not a regular court, a regular judicial tribunal, or a regular court from being the determiner of somebody's civil rights and obligations to this extent. Let me explain it. In the section 182 that we were talking about, that in the first Alteration Act, they removed paragraph I of subsection 1, which was the previous paragraph that was abused and which gives potentials for abuse if impeachment is allowed, impeachment and removal is allowed to be a ground for preventing somebody from seeking office in future. Remember that that provision was where a person indicted for embezzlement or fraud by a judicial commission of inquiry or an administrative panel, once there's such a panel and there's a recommendation accepted by government, without going through any court, a person could be prevented from seeking office. And you remember how it was abused in Abia State? How it became a comedy of, it was a parody of errors all through. Chief Obasanjo formed a panel. He set up a panel at the federal level to check Dr. Joseph Carlo of Abia State. The panel returned something suggesting that the person was, had been indicted and therefore will prevent him from holding office in future. The state governor of Abia State set up his own panel, and the panel indicted the President Obasanjo. So it becomes ridiculous. And that was what these people, when they were reviewing the Constitution, said, no, this joking is enough. They removed it from the provisions of our Constitution. So it will be a dangerous thing for us to get back to it. You now allow impeachment to be brought back as that paragraph I. And then people will go and do the same thing my lawyer friend Ochala SCN had also recognized. Some people abuse these things. And when you abuse it, it means that a person without intermediation by the courts will be prevented from seeking public office. I don't think that would be the right way to go at this time. I'm not quite sure it would be the right way to go.
Ray Sacharike, thank you very much. It's always a delight to listen to you on our program. But do stay by and listen to what Senior Leonard Silk Ocholi has to say about what your response so far.
I'm not suggesting that paragraph I be reintroduced. What I had in mind, which I have not yet voiced, is supposing we make impeachment a little bit more difficult so as to introduce the needed sanity, because the many of them I have seen in the last few years have been abused. A lot of them. So supposing we make it a little bit more difficult, and this is what I have in mind. Supposing we now say that 7-man panel's recommendation be submitted to a special court. Not a quasi-court, a special court.
What is a special court?
Properly constituted under the Constitution. Constituting of either a serving High Court judge and 2 other members, to now subject where the persons, they now treat that 7-man panel as more or less an indictment worthy of trial. Then we now introduce this level where the trial will actually take place within the given number of months, or maybe days or weeks, maybe 3 months. If they go ahead this time around, lawyers are free to represent the parties, go through the trial, and either secure a conviction. If conviction is secured, then removal can take place. That will tighten the rope of impeachment and will remove it from the almighty clause of the House of Assembly as they are for now.
Okay, well, Leonard Senior Advocate James Ocholi, again, always a pleasure having you on the program. Thank you for your illuminating perspectives on this conversation this morning. We'd also like to thank another Leonard Senior Advocate. Claire's been saying sick makes SAN as Senior Advocate.
Yes,
yeah.
I know.
Yes, but you want to wear one? Anyway, that's Joage would like to thank you for coming around. And Claire was head of Achara as well.
All right, of course, I'd already thanked Professor Ray Sachara, Professor of Constitutional Law. Many thanks to you. All right, this is Good Morning Nigeria. We've been looking at, of course, the implications of the Supreme Court judgment on the case brought before it against Governor Ayo Fayose. We'll take a short break. When we come back, we'll talk sports. All right, quickly now to sports. Barcelona got an away 3-1 win against PSG, while FC Porto defeated German League champions Bayern Munich. Of course, on the second day of Champions League quarterfinals. Musba Dan Wahab has all the details.